I would like to ask the Secretary, Mr. Weir, to read the statement of breach.
In the matter of the second schedule of the Elections Act, in the matter of breach of the Electoral Code of Conduct, subject Honorable Sabina Chege, Muranga County Woman Member of the National Assembly. Statement of breach. It is breach of Clause 6A and Clause 6L of the Electoral Code of Conduct. Particulars of breach are as follows. That Honorable Sabina Chege, Muranga County Woman Member of the National Assembly, you are accused that on the 10th of February 2022, while at a public rally at Isibuye area within Vihiga County, you uttered the following words. Mnajua kule Central, nimesikia wengine wakisema, hapa tuliwaibia. Kuna kaukweli kidogo. Lakini, kama tulijua kuiba, si hata hii tutafanya nini? Wanafikiria wao ndio wajanja. Which words contained in your statement creates an impression that the Jubilee Party, to which you belong, in quotes, stole the 2017 general elections and that it plans to steal or compromise the general elections 2022. Further, your statement casts aspersions on the integrity of the general elections 2017, specifically that the voting system developed by the Commission is penetratable, not secure, and falls foul of the requirements of Article 86 of the Constitution of Kenya 2010. Mr. Chairman, that is the statement of breach. Thank you.
I don't know how you want to proceed, Senior Counsel Rengo.
We want to address you on some preliminary issues on several categories. I'll make an opening statement, and my learned friends will proceed to several. As you know, the provisions of the Constitution are mandatory, especially when they apply to a body such as this committee. And there's Article 50 action. Whenever a public body is vested with authority to deal with matters which touch on constitutional rights, particularly in the Bill of Rights, there must be strict compliance. And Article 19 of the Constitution stipulates that the Bill of Rights is an integral part of the Kenyan democracy. And therefore, first of all, we have a problem with this statement of breach. Because before you can make accusations against anybody, those accusations must be set out in clear terms. And as you can see from the charge, it is a redacted version. It's a redacted version of what is purported with the statement by Honorable Sabina Chege. And if you look at the rhetorical syntax of this purported statement, there is no clear assertion. To be accused of committing a breach, and therefore the fact that it has been redacted, in our view, this is for a collateral purpose to defeat the ends of justice. you are not telling us clearly what she has, what she's accused of saying. And that's why you have statements, mnajua kule Central, nimesikia. That is a rhetorical statement, couched with an element of sarcasm. And then there are statements like, tutafanya nini? Again, how do you draw the inference on a statement which is redacted? What did she say that follows the words nini? So I think for you to have a clear statement of breach, they should set up in clear terms so that Honorable Sabina Chege would know clearly what she's being accused of, said and done, and the full impact of those words can only be understood by having a proper and unredacted version of what she is accused of saying. Secondly, and this one Honorable Tina Amolo is going to deal with in extenso, you are the one, this body as the one, is the one which, this committee, through the secretary, is the one that has read these accusations to Honorable Sabina Chege, and now you're presiding over what is a quasi-trial. You have no independent prosecutor here. You are the one making the accusations. The accusations is in the hand of the Electoral Commission, or a committee of the Electoral Commission, presided over the chairman. So there's a clear breach of the tenets of natural justice, that you cannot be both the accuser and the court to determine as to whether or not Sabina Chege should stand trial, as it were, on these issues.
Members of political parties or persons who support political parties and the government. The object of the court is to promote conditions conducive to the conduct of free and fair elections, and a climate for tolerance in which political activity may take place without fear, coercion, intimidation, or reprisals. The Electoral Code of Conduct has a lifetime. For the purpose of a general election, it applies from the date of publication of a notice of election until the swearing in of newly elected candidates. This is the election period as defined under Section 2 of the Elections Act. The notice for the 2022 general election was published on the 20th of January 2022 by special issue of the Kenya Gazette Notice Volume CXXIV number 14, and thus makes the committee and its operations alive and recognizable in law. Clause 6A of the Code requires that during the election period, political parties, members of political parties, and indeed all those bound by the Electoral Code of Conduct must publicly and repeatedly condemn violence, intimidation, and avoid the use of hate speech, language, or any kind of action that lead to violence or intimidation. In addition, Clause 6.1 of the Code requires that all persons bound by the Code should reassure voters with regard to the impartiality of the Commission and the secrecy and integrity of the ballot. The respondent herein is a member of Jubilee Party and a serving Murang'a County woman, a member of the National Assembly, having been elected on a Jubilee Party ticket. Indeed, Jubilee Party is a registered political party which has submitted its nomination rules to the Commission and given indication that it will be participating in the 2022 general election. In the premises, the respondent is subject to the Electoral Code of Conduct and is under duty to abide with the same. In terms of the provisions of Article 252 of the Constitution, the Commission may undertake investigations on its own motion. In the matter before the committee, the Commission's attention was drawn to the media reports and material bearing utterances by Honorable Sabina Chege, and on his own motion was seized of this matter. Indeed, the question as to whether the Commission has jurisdiction to hear a matter such as the one before it has been the subject of litigation in the High Court in Nairobi, Judicial Review Miscellaneous Application number 592 of 2017, Republic versus Independent Electoral and Boundaries Commission, in the matter of the Honorable Attorney General and Honorable Jessica Mbalu, ex parte Professor Philip Kaloki, where the court, while hearing a judicial review application filed by Professor Philip Kaloki challenging the jurisdiction of the Electoral Code of Conduct Enforcement Committee on grounds similar to the current objections, reiterated that the provisions of Section 110 of the Elections Act on the observance and enforcement of the Electoral Code of Conduct, it reiterated the provisions of Section 110 of the Elections Act on the observance and enforcement of the Electoral Code of Conduct. It outlined the powers of the committee and concluded that the committee was right in executing its mandate. Further, that the committee is not bound by the provisions of the Criminal Procedure Code and the Evidence Act. The court, upon examination, found that the procedure followed by the committee and the decision rendered was within its powers and thus upheld the same. The court declined to issue the order sought by the applicant and dismissed the petition. Against this background, the Electoral Code of Conduct Enforcement Committee has jurisdiction and is legally seized of the matter before it for hearing and determination. We make the following orders. One, that the preliminary objection raised by counsel for the respondent on 15th February 2022 is hereby dismissed. And two, this matter shall proceed to full hearing. Dated 15th February 2022. Those are our orders. We can give you copies of the ruling, and I direct that the matter proceeds for hearing. Mr. Owie.
Mr. Chairman, just Mr. Chairman, we have had the ruling. However, since this is our first hearing, we would ask the commission because our hearing here was in order to proceed to a full hearing, we will need to take full instructions from our client, and we will also need to get material from the Commission so that we would know if any statements have been recorded in pursuance of this matter. If any statements have been recorded, we would think that in order to have a proper hearing and an equality of arms, that those statements should be availed, and the audio recording, if any, of the statements complained of, and that would require about a week to 10 days for us to prepare for that hearing. And I think that's a reasonable request. This was mentioned earlier. The summons indicate that the Commission is seized of a report and material. And I think in the interest of a fair hearing and tenets of natural justice, I think this material should be made available to us so that we know exactly the nature and the substance of the case that we have to meet.